I'm Richard Sallybanks. I'm a partner in the business crime team at BCL Solicitors, and I specialise in representing corporate executives and high net worth individuals in business and financial crime investigations. Like many of the partners at BCL, I have substantial experience in representing individuals who find themselves suspects in investigations into fraud and corruption conducted by the Serious Fraud Office, the SFO. In recent years, the SFO have been trying to encourage suspects to cooperate in their investigations. There's a statutory scheme which covers this, and the advantage of cooperation is that the person, albeit having to plead guilty, receives a lesser sentence at the end of the case than they would otherwise receive if they pleaded guilty without cooperating or fought the case at trial and were convicted. A couple of recent cases involving the SFO, Petrofac and Unioil, have featured cooperators. But I think there are three main points to consider when looking at the issue of cooperation, and albeit anybody who's a suspect in an SFO investigation needs to take legal advice on their position, that's even more the case if somebody is thinking of cooperating in an investigation. There are three things I want to touch upon in relation to cooperation with the SFO. The first is the process that has to be followed when engaging in cooperation. The second is what I call the risk-benefit analysis, and the third is the fact that there is still residual uncertainty about the sentencing outcome. So turning to the first area and the process that's followed, there's a statutory framework set out in the Serious Organised Crime and Police Act, albeit now in the 2020 Sentencing Act, which deals with how cooperators can enter into what's generally known as a cooperating defendant agreement. They plead guilty, and in return for their cooperation, which can involve giving evidence at trial against other people, they receive a substantially lesser sentence. But the process by which a suspect ends up with a cooperating defendant agreement does require the person concerned to engage in a series of interviews with the SFO, variously called scoping interviews, cleansing interviews, but they're all interviews under caution, which means that what the person is saying in those interviews could be used against them if, in this scenario, the intended cooperation doesn't play out and result in an agreement, and the SFO go on to prosecute that person and, in theory at least, can use what is said in the interviews against that person at trial. Now, this creates an obvious risk, and that's why anybody thinking about engaging in this process needs to do so through lawyers to seek to minimise the risks that are inherent in that process. The second area I want to touch upon briefly is what I call the risk-benefit analysis. Now, a cooperating defendant agreement with the SFO necessarily requires the person to plead guilty, and there's no doubt that somebody who pleads guilty having entered into one of these agreements will be treated more leniently at sentence than would otherwise be the case. But as I say, it does require a guilty plea, and what somebody considering this cooperation route needs to give careful thought to is whether, by cooperating and by assisting the SFO in their investigation, they are in fact bringing about a prosecution of them that might not otherwise follow. Now, we've seen a number of cases in recent years where large corporates have accepted criminal responsibility for corruption or fraud committed by their senior executives. But in some of those cases, none of the executives have been prosecuted. And in those cases where executives have been prosecuted following DPAs, as yet the SFO have not secured a single conviction. And that is something that a putative cooperator has to weigh in the balance. By cooperating, am I bringing about something, i.e. a prosecution of me and a finding of guilt that may not otherwise follow? The third area I want to cover briefly is the residual uncertainty about the sentencing outcome. Now, it's not possible or permissible for the SFO to say to somebody who cooperates in their investigation that in return for your cooperation and the guilty plea, you will receive a sentence of X. Sentencing is a matter for the court. But there have been a couple of cases, one of which involved somebody represented by this firm, and another case most recently arising out of the Petrofac investigation, which have established the precedent that if, when sentencing a person for the guilty plea, their mitigation, which will include not just the guilty plea but the cooperation, brings the level of sentence down to the threshold at which the court can suspend it, then, all things being equal, the court will do that. And that is the obvious advantage for a cooperator, and the carrot that the SFO will wave when seeking to encourage cooperation is that the person concerned can avoid a prison sentence. Now, it doesn't follow that every cooperator will avoid prison, and we've seen in the recent Unaoil case that the person who cooperated in that, albeit after he'd been charged, still received a prison sentence, albeit one that was substantially less than would have been imposed had he not pleaded guilty and cooperated. So the advantages of cooperation in terms of sentence are there, but again, it's very important that somebody contemplating a cooperating approach to the SFO does so in full recognition of the risks and uncertainties that are involved in that process.